Welcome to U.S. Immigration TV. Did you know that even if a person already has an approved petition, it could be automatically revoked as of the date of its approval? And depending on the circumstances, their priority date or place in line would be lost, and the person may have to start all over again with their hopes and dreams perhaps being lost forever. In this video, I will discuss some of the ways by which a person can find that their petition was automatically revoked. Sometimes they don't even realize it and it's been revoked, and they're waiting years and years only to find out there's nothing more that can be done. So make sure to watch this video until the end, and of course, like, share, and subscribe to this channel. Now, what are some of the reasons or grounds that a petition could be considered automatically revoked? One way is the failure to apply for a visa within 1 year if a person is processing their immigrant visa at the embassy. Now, this is where the beneficiary's visa registration is terminated at the National Visa Center, NVC, or at the embassy because of the person's failure to apply for a visa within 1 year of being notified that the visa is available. It's kind of like a visa is a seat on an airplane. You have your reservation, but if they are boarding the plane and you do not check in, they're going to cancel your reservation and give it to the next person on standby. Now, in rare circumstances, it could be possible to reinstate registration and salvage the petition because of circumstances beyond the alien's control, or perhaps the registration was prematurely terminated. Another ground for automatic revocation is where the petitioner withdraws the petition in writing, and the petitioner cannot later change his or her mind and then ask USCIS to reinstate the petition. Once it's withdrawn in writing, it's withdrawn, it's terminated. And I've come across many situations, especially in marital situations, where a couple may have gotten into a fight, and then in the heat of the argument and out of spite and anger, the petitioner writes to the USCIS saying that they want to withdraw that petition. They later make up, but that petition is now considered terminated. A new petition would have to be filed. Death of the petitioner, unless USCIS believes it would be inappropriate to revoke the petition and grants humanitarian revalidation or reinstatement. Or if the beneficiary happened to have been in the U.S. at the time of the petitioner's death, they could possibly qualify for reinstatement under Section 204L, which is what I call the survivor law. Death of the principal beneficiary. In situations where the beneficiary is outside the U.S., humanitarian revalidation is not available if the principal beneficiary, meaning the one who was under petition, dies. In that case, the derivatives are out of luck. And I've had many of those situations where somebody's under petition, they have a wife and several kids, they die, but the wife or husband is out of luck, as well as the kids. No humanitarian revalidation if the principal beneficiary dies. However, there could be hope for derivatives when the principal dies if they are eligible under the survivor law or Section 204L. And that means they were in the U.S. at the time of death. This would apply either to a family-based or employment-based petition. In fact, I had one case where a brother was petitioned by his sister. He and his wife happened to have been in the U.S. The brother died. That's the principal beneficiary. But the wife was still able to obtain a green card through the F4 petition because her sister-in-law, the petitioner, agreed to continue. Another ground for automatic revocation is where an unmarried son or daughter of a lawful permanent resident, that's LPR or green card holder, gets married before their parent naturalizes. In other words, An immigrant parent can never petition a married child. And even if the petition is filed when the child is single, meaning category F2B, but the child later gets married, the petition is automatically revoked. This could also apply to what we call secret marriages, where you say, oh, I'm going to get married, but the contract will not be recorded. No, secret marriages also count and could void the petition. Bottom line, if the single child gets married before their visa is issued and before the petitioner naturalizes, the petition is automatically revoked, even if the petitioner naturalizes after the child's marriage. No. On the wedding day, was the petitioner a citizen or not? If they were not, petition void. Another ground for automatic revocation is where the marriage forming the basis of the petition is legally terminated, such as by divorce, annulment, etc., except in situations where a spouse is considered battered or abused by the petitioner, either physically or mentally. A person can qualify for a self-petition as an abused spouse if they were physically abused or even mental cruelty. Another ground of automatic revocation, similar, is but where the spouse of an abusive U.S. citizen or green card holder gets married to someone else unless their self-petition has already been approved. In other words, if they are filing a self-petition as an abused spouse, but before that self-petition is approved, they marry somebody else, it's automatically revoked. Another ground for automatic revocation of a petition is where the petitioner loses his or her status as a U.S. citizen or lawful permanent resident. They renounce citizenship, or let's say, for example, a green card parent files a petition for their unmarried son or daughter, but then they move back to the Philippines for many, many years, and it's considered that their green card has been abandoned. If the green card is abandoned, then the petition based on that green card may no longer be valid if the petitioner is no longer a green card holder. Now, I've come across many valid petitions that were automatically revoked because of neglect, oversight, or misunderstanding of the law. In fact, one of the biggest grounds for automatic revocation is what I just mentioned before, which is the failure to pursue a visa with the NVC or embassy within 1 year, or another one, major one, is a son or daughter of a lawful permanent resident parent getting married. Also, aside from automatic revocation, USCIS can also revoke your approved petition if they believe it was approved in error or because of your fraud or concealment of the truth and hiding your ineligibility, such as a person being petitioned as single but they're secretly married, or you were caught later in a fixed marriage. If your petition was revoked, or USCIS or NVC is threatening to revoke your petition, you should consult with an attorney who can evaluate your situation and see if there are ways in which the petition could possibly be revived, saved, or reinstated, demonstrating that revocation perhaps was not in accordance with the law, regulations, or circumstances. I hope you have found this video helpful and informative, if not for yourself, for somebody you know, a coworker, a family member, a friend. Therefore, please like, share, and most importantly, subscribe to this channel, because I'm always posting new videos on topics which I believe you will find helpful, informative, and useful. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.